So welcome everyone to the week 11 tutorial on international human rights. And this time we focus on the topic of respecting, promoting, and fulfilling international human rights. So welcome again to Clinton, Clarissa, Nadine, Tamara, Ilyonka, Heidi, Mercy, Jack, Pida, Ainsley, and Tony. Thank you for joining tonight's session. And of course, as you realize, we're very close to the end game. We only have 1 week to go before the end of the term. So thank you for continuing on with this journey to learn more about public, international, and human rights law. And so last week, we started our discussion about international human rights. And I would imagine that there has been a lot of interest actually among students pertaining to international human rights because, again, it is a topic that often crops up, and especially in the context of the Universal Declaration of Human Rights. And when we had our discussion last week, we essentially focused on which of these international instruments may actually be binding upon states. And we noticed that the Universal Declaration of Human Rights is not a binding legal document. It's just a declaration, and it's not meant to be considered a treaty under the Vienna Convention on the Law of Treaties, mainly because it was never the intention on the part of states to be bound by that particular declaration. It was just a statement of declaration, a statement of intentions. And we also had a look at the International Covenant on Civil and Political Rights. And we observed that even though a state may actually... That's my dog barking. So even though a state may be a party to the International Covenant on Civil and Political Rights, and we assume that there may be a breach of the obligations of a state in relation to that particular covenant, it doesn't really give rights. It doesn't give rise to the right of any individual to file a complaint before the Commission on Human Rights. So for an individual to have any remedy and file a complaint before the Commission on Human Rights, it is also important that a state that is a party to the International Covenant on Civil and Political Rights must also be a party to the optional protocol to the International Covenant on Civil and Political Rights, because it is the optional protocol which actually allows individuals the right to file a complaint before the Commission on Human Rights, because otherwise only states as the main subjects of international law actually have the right to file a complaint against another state for any violation of the ICCPR. Now, our focus tonight is really to observe that there are various levels of obligations on the part of states pertaining to international human rights. We will observe that on the one hand, a state may claim to have respected international human rights, but perhaps the mere fact that a state respects particular human rights will not mean that it leads to advantages or benefits on the part of citizens. For example, if you examine the International Covenant on Economic, Social, and Cultural Rights, that particular covenant provides a lot of civic, economic, social, and cultural rights, including the right to education, the right to housing, the right to adequate living, and so on. But what does it mean for a state to actually respect that right? We know for a fact that a lot of the parties to that particular covenant do not have the infrastructure, do not have the capability to provide, for example, a living wage, to provide housing to everyone, or perhaps even to provide proper food and shelter to people, or even proper facilities for physical and mental health. Would it mean that they are in breach of, would it mean that a state party, therefore, to the International Covenant on Economic, Social, and Cultural Rights would be in breach of its legal obligations under that covenant if it fails to, provide adequate housing? So in other words, is respecting the right sufficient? Or is there a requirement that a state must try to fulfill the requirement? I mean, the legal right. So we draw attention to the difference between, for example, that no state should attempt to unlawfully interfere with the rights and freedoms of individuals under the International Covenant on Civil and Political Rights. So it is a prohibition. It is a prescription not to. So if the state can easily do that, it doesn't do anything, it has respected the right. But, so in other words, if a state doesn't do anything about adequate housing, it just respects the right of people to adequate housing, is the obligation of a state in relation to the covenant satisfied? Or is there a requirement to do more? And so therefore we observe that in international law, particularly in relation to international human rights, there is a general agreement that there are varying levels or typologies of international human rights obligations on the part of states. So there's a difference between merely respecting it, promoting and fulfilling it. And it also raises the question that what if a state in fact respects particular international human rights, which should be the right against arbitrary detention, and yet in that particular state, there are instrumentalities, there are private individuals, there might be gangs, there might be groups of people that end up interfering with the rights and freedoms of individuals. There might be people who are responsible for just unlawfully detaining people, probably subjecting them to torture. Would it mean that the state may be in violation of the International Covenant on Civil and Political Rights if it fails to do more than just respect the right? Because in this particular case, the scenario I gave, it wasn't really the state doing it or being responsible for the violation of those international human rights under the International Covenant on Civil and Political Rights. So that will be the focus of tonight's discussion, looking at the typology of international human rights and looking as well at the possible restrictions pertaining to international human rights. So after studying this topic, you should be able to discuss and explain the typology of states' obligations relating to human rights and the conditions under which the regime of human rights may be restricted. Now, before I continue, I wanted to know if there might be anyone who might have a question or a comment. Okay, so there being none, tonight I propose to cover 5 discussion questions for us to dig deeper into the topic. And at the end of the tutorial, that's when I cover the quiz question. We will begin with 4 questions, and then we examine the quiz question itself. So let's begin with question 1. This is a bit long. Can I get a volunteer to read question 1 for us, please? Can I get a volunteer? Was that Tamara? And then who was the other one? Was it Clarissa? So Clarissa can probably read question 2. We'll begin with Tamara for question 1, then Clarissa, thank you. We'll read question 2. So Tamara, can you read question 1 for us, please?
So the state of New Kenya is a party to the 1966 International Covenant on Economic, Social and Cultural Rights. Article 7 of the ICESC provides, the states parties to the present covenant recognise the right of everyone to the enjoyment of just and favourable conditions of work which ensure, in particular, a remuneration which provides all workers as a minimum with 1. Fair wages and equal remuneration for work of equal value without distinction of any kind, in particular women being guaranteed conditions of work not inferior to those enjoyed by men with equal pay for equal work. 2. A decent living for themselves and their families in accordance with the provisions of the present covenant. Just taking it on, there we okay, that's okay. The New Kenya National Trade Union has for years lobbied with the state of New Kenya to increase the state's minimum daily wage from $2 to $5 without success. The trade union believes that the $2 minimum daily wage is grossly insufficient for New Kenyans to have a decent living. An international report has shown that other states who are parties to the ICESC have the following minimum daily wages: Australia, $138, UK $117, New Zealand $113, US $80, Mexico $4. The trade union has now approached you as solicitor for advice. It wants to know if the state of New Kenya is in breach of its legal obligations under the 1966 International Covenant on Economic, Social and Cultural Rights. It also wants to know if it can file a complaint with some international body to force the state of New Kenya to increase the minimum wage. Advise the trade union.
Thank you, Tamara. Can I get a volunteer? When anyone is ready, can I perhaps get somebody to try to provide advice to the trade union? You might be aware that there are so many states today where the minimum wage is about $1 a day. It's pretty tragic, right? Are you aware of that? So there are some states where people are actually living, being paid about $1 a day to work. Countries such as the Philippines, for example, I think they're being paid about $8 a day. India, probably less. And that's the reason why a lot of outsourcing is happening to these states. And yet, India and the Philippines are signatories or are parties to the International Covenant on Economic, Social, and Cultural Rights. Okay, what do you think? Can I get somebody to to provide the advice to the trade union? Can I get somebody to attempt an answer? Think about it.
I'll attempt an answer, Manjo. I don't know whether it's right.
Okay, go ahead. Yeah.
I think the whole thing depends upon the ability of the country to be able to pay.
Go on.
Some of these third world countries, the wages are very, very low. Then the countries themselves are not able to sort of pay big money. But however, you do have other countries where they're earning huge amounts of money, and it's in a hands of a few.
Yeah.
And it's really a conundrum. You just don't know what to say unless you know the specific circumstances of the country, really, I think.
Mm-hmm. So we will assume that New Kenya is what you might call a third world country. So would New Kenya be in breach of its legal obligations? That's one of the first questions we need to answer.
It wouldn't be if it really and fair dinkumly is unable to afford to pay the increase. I think, but however, if it's fudging in any way, shape or form and is able to pay, yes, I think then they're in breach of their obligations.
Okay, thank you, Peter. So I would imagine that's the correct answer. Actually, there are very few cases that we examine, that we see involving these types of questions. A lot of these questions actually have been answered, for example, in the case of South Africa, and Ilyonka would probably be familiar with this, pertaining to a complaint on the filed by South Africans before the South African Supreme Court, trying to compel the South African government to provide state housing to certain South Africans on the ground that South Africa is a party to the 1966 International Covenant on Economic, Social, and Cultural Rights. Okay, but as a general rule, as pointed out by Peter, the international community does recognize, as a matter of general principle of law, that any attempt to try to comply with this covenant is really based on the capacity of states to undertake it. And in fact, if you examine the particular wording of the International Covenant on Economic, Social, and Cultural Rights, what typically happens is that it would require the states to furnish a report to the committee that is responsible for ensuring that the parties are complying with their obligations under the covenant, to provide a report on the steps that they are taking in stages to try to comply with their obligations under the covenant. So it's merely providing a report on how they're trying to comply. And so therefore that provides a huge leeway, therefore on the part of the state to say that, you know, we're trying to comply by doing this and that. We're trying to comply based on our capacity. So in fact, Article 17.2 of the covenant also provides that the reports that states may provide to the council, to the Economic and Social Council, which is responsible for administering this particular covenant, that report may indicate the factors and the difficulties that states are facing in trying to fulfill their obligations under the covenant. So there is a recognition in the covenant itself under Article 17.2 and Article 17.1 that different states have different capacities. They have different, difficulties and factors that may affect their ability to comply with the legal obligations under the covenant. So it's difficult to say that simply because a state seems unable to provide what might be called an adequate or a living wage doesn't mean that there is now non-compliance, because the requirement is simply for them to provide a report. Okay, and the other problem really is that when you talk about what might be considered to be a living wage, that is a very a very broad term without a single definition, because what is a living wage in Australia or the US is different from a living wage in China or Afghanistan or a third world country. So there is a huge variation, and the international community recognizes that as well. Now, I mentioned South Africa because in a case that was filed in South Africa before the complaint was not filed with the Economic and Social Council. So first of all, let me answer that question. It also wants to know if it can file a complaint with some international body to force the state of New Kenya. There is no international body that can force any state that is a party to the covenant to try to increase the minimum wage. There is no such thing. There is no international body, let's be clear. So even the Economic and Social Council, which is responsible for administering the covenant, can only receive the report, and they can only issue recommendations. That's it. These are non-binding, okay? And so certainly there is no international body that can force or compel any state to comply with these obligations under the covenant. Now, and in addition, an individual cannot file a complaint with the Economic and Social Council. It is only when a state is a party both to the International Covenant on Economic and Social Cultural Rights, as well as the optional protocol to the International Covenant on Economic, Social, and Cultural Rights. So it is the optional protocol which does provide individuals the right to file a complaint with the Economic and Social Council. Only to file a complaint, but even then, the Economic and Social Council's power is limited to giving a recommendation to the state concerned. It has no legal authority to issue any binding decision. Now, having said that, I mentioned that the case of South Africa, where certain individuals tried to file an application with the South African Supreme Court, saying that South Africa was in breach of its obligations under the International Covenant on Economic, Social, and Cultural Rights pertaining to the need to provide housing for individuals. And in the context of the South African Constitution being read in relation to the International Covenant on Economic, Social, and Cultural Rights, the South African High Court, I'm not sure if it's a High Court or Supreme Court, ruled that the state of South Africa was in breach of its international obligations, and under its constitution, there was a requirement that the South African government must do more in order to provide housing to individuals. So in other words, what then happens is that there is an attempt on that any attempt to try to complaint on the basis of a breach of an international obligation on the basis of the covenant will usually be done through the domestic channels, because there's also a requirement under the international covenant on economic and social cultural rights that there must first be an exhaustion of domestic remedies. I have here a point from Ilyonka. Would the trade union go outside the state for remedy, as it appears the domestic avenues have been exhausted? Does the trade union have standing to directly approach a UN organ or a constitutional court? Good questions. So number one, would a trade union, can a trade union have standing to approach a UN organ? The only UN organ that it could possibly approach would be the Economic and Social Council, which has in fact been created under the International Covenant on Economic, Social, and Cultural Rights. I would imagine that the trade union might have the power to represent its members for the purpose of filing a complaint. I don't see any problem in doing that. So in that case, therefore, the Economic and Social Council is considered an organ of the United States, an organ of the United Nations, but the Economic and Social Council is not a tribunal like the ICJ. It cannot make binding and enforceable decisions, unlike the ICJ. And even then, as far as the ICJ is concerned, the only parties that can be complainants before it would have to be states or non-governmental organizations. And when we speak of non-governmental organizations under the UN Charter, we're not referring to a non-profit organization that we see, not like, what are examples there? What are examples of non-governmental organizations? So Greenpeace, we're not talking about them. We're actually talking of non-governmental organizations in the sense that these are also non-governmental organizations created by states. So it could be the ECOSOC, it could be the UNICEF. So these are the non-governmental organizations that have the legal standing to file a complaint before the ICJ, but not the non-governmental organization that we usually understand. So there is no constitutional court that you can go to for the purpose of enforcing the possible obligations of a state under the International Covenant on Economic and Social Cultural Rights. From Ilyonka, no, the constitutional court is where the housing issue was heard. Okay, so is that the way it was called in Africa, in South Africa, Ilyonka? So the correct term there is the constitutional court. Okay.
Yeah, sorry, Manjo, they've got a sitting constitutional court that hears all constitutional matters.
Okay. So it's called kind of a Supreme Court in South Africa, right?
No, it's called the Constitutional Court.
Okay, it's a constitutional court.
The Supreme Court is something different, and there's a Court of Appeal. So yeah, it's a civil system.
Okay, very good. So in the South African case, what we have was a complaint filed before the Constitutional Court, and the South African Constitutional Court, looking both at the South African Constitution as well as the obligations of South Africa under this particular covenant, felt that there was a requirement on the part of South Africa to try to fulfill its obligations. So you can see the distinction there. On the one hand, it's merely respecting. Respect means refrain from interfering in the right. It's a different thing to do more by trying to fulfill an obligation. And the Constitutional Court of South Africa ruled that South Africa needed to fulfill its obligations. It was insufficient to just kind of respect and this particular right and do nothing. Okay, from Peter, would you describe a state that lost 14 Maseratis and 3 Bentleys, a third world state, Manjo? Which state? Where did this happen, Peter? So it happened somewhere. Yeah. So that's a problem now, right?
It happened in Papua New Guinea.
Oh, okay. Oh, I see.
And they spent a heap of money and bought 500 cars, including 40 Maseratis, which would last 5 minutes up there on their roads, and 3 Bentleys for the APEC conference last year, and they've lost Maseratis and the Bentleys.
They just disappeared.
Yep. Politicians will have them.
Okay, thank you. So any questions on question 1? We're good. Yeah, corruption is management. That is an issue. Questions on any questions? We're good. we move on to question 2. Can I get Clarissa? Is she still there? Yeah, Clarissa, do you mind reading question 2 for us, please?
Okay.
When it appears.
Mm-hmm. The state of Venetia, a state party to the 1966 International Covenant on Civil and Political Rights, recently passed a law that authorized the National Police, upon authority issued by the state's Department of Justice, to monitor and record internet and email communications of homes that belong to individuals who are suspected of committing violations of the country's civil and criminal laws. The Union of National Lawyers is alarmed that the draconian Big Brother laws interfere with the rights to privacy of individuals and families. It is considering filing an application with the state's Supreme Court to declare the invalidity of such a law on the ground that it violates Article 17 of the 1966 International Covenant on Civil and Political Rights. Article 17 of the Covenant provides, 1. No one shall be subjected to arbitrary or unlawful interference with his privacy, family, home, or correspondence, nor to unlawful attacks on his honour and reputation. It has consulted you as the Union's top legal advisor to provide legal advice. Advise the Union.
Thank you, Clarissa.
Is Venetia a party to the protocol that allows other parties other than the states to put in objections?
We can assume that the state of Venetia is also a party to the optional protocol to the 1966 International Covenant on Civil and Political Rights. Is the state of Venetia in breach of the covenant?
Would it again not be a matter of sort of interpretation for the country?
Go on.
Would it, for the state of Venetia, wouldn't it be, if they'd legislated that that was part of their crime fighting and other matters, that wouldn't it, and that would be that they would interpret that as normal, as Leonka just pointed out, sovereignty and justified by the level of crime. So what Venetia would say is acceptable and not violating the privacy would be vastly different to what sort of Australia would, or even China, or those other surveillance states.
Okay. That's a good point you're raising. I'll go back to the issue about sovereignty in a short while. But about that point, but wouldn't the state of Venetia be in breach of its obligations? Because the obligation under Article 17 is quite clear. No one shall be subjected to arbitrary or unlawful interference with his privacy.
Well, if they passed a law, it's not unlawful,
okay,
and if it's not,
that's right. So that's a good point. Let me just go back, and then I'll keep on going. Let me just go back to that issue of sovereignty. So the problem with sovereignty is that, once a state has become a party to the covenant, the understanding is that to an extent, part of its sovereignty that state has willingly given up part of its sovereignty in relation at least to its obligations under the covenant. Okay? So in that case, if a state, for example, binds itself to do this, it means that the state has a legal obligation to do it, which means therefore that the full and plenary or supreme power of a state to do something has to an extent been diminished by whatever obligations it has accepted. So that's the point about sovereignty. Now, Jack is correct on this point. Number one, if there is a law that interferes with the privacy, then it can no longer be unlawful interference, because that's what it says. What is prohibited is an unlawful interference. If there is a law about it, then it can no longer be unlawful. It has to be lawful interference. But what this also tells us, secondly, as pointed out by Jack, is that it is up to a state actually to try to interpret its obligations under the international covenant, because this is broad language. What might be arbitrary to one, might be arbitrary to one state, might in fact not be arbitrary to another. So there is that leeway. There is the way you operationalize, the way you try to interpret a particular provision under the covenant is really subject to the interpretation of a state. There can be no single interpretation, because that interpretation will have to be reliant on the Commission on Human Rights, for example. Now, the third thing that we need to understand is that a lot of these rights, for example, under the ICCPR, are not absolute. They are subject to limitation. So they can be limited by a state. And in fact, number 4, as a matter of general principle of international law, there is an understanding that even the parties to the covenant have the right and the power to impose limitations on the obligations that they have accepted on the basis of the covenant. So for as long, for example, as the limitation is justified, because it might be responsive to a public or social need, it pursues a legitimate aim, and is proportionate to that aim, that issue about proportionality, then the limitation or the restrictions that a state may impose on certain rights recognized under the covenant will be considered valid and not in breach of the obligations under the covenant. So the rights, therefore, under the covenant are not necessarily absolute, and they're not necessarily to be understood only in a single way, because different states may have different interpretations depending on their particular needs and depending on their own capacities. Okay, so from Ilionka, sovereignty is justified by the level of crime. They have a greater legal obligation to ensure the safety of the citizens. Yeah, so at the end of the day, it is up to the state to determine the kind of laws it will impose. So the laws that that they will pass, in this case, it's a law passed by their parliament, can potentially be interpreted in a way that harmonizes it with the obligations, with the obligations of the state under the covenant on civil and political rights. They're not necessarily inconsistent. The job of courts in trying to make a ruling on a law that potentially might violate the Constitution or may violate an international obligation is, first of all, to try to determine if the provisions are necessarily inconsistent, and the goal is always to harmonize. And in this particular case, it will be quite clear that it's easy to harmonize the obligation on the one hand to avoid or to refrain from arbitrary or unlawful interference, with the obligation, with the requirement on the part of the state to try to ensure that the laws of the country are not violated. Okay, questions? Okay, so we could move on to question 3. And I did point in the study guide that I have, I cited the UN Subcommission on the Prevention of Discrimination and Protection of Minorities, the Syracuse Principles on the Limitation and Derogation of Provisions of the International Covenant on Civil and Political Rights, that there is an understanding that it is within the power of the states to actually restrict certain rights recognized under the International Covenant on Civil and Political Rights. Okay, question 3. Can I get a volunteer?
I can go again if you want.
Yes, thank you. Melissa? Yep.
At a family court hearing involving an application for a parenting order before the Federal Circuit Court of Oceania, the judge refused to allow the 9-year-old daughter of Sean Matthews. This deeply upset Sean because he knew that his daughter, who is very close to him, would state her preference for her father in the child custody case. Sean wished to know if the state of Oceania might be in breach of the 1989 Convention on the Rights of the Child, which entered into force on 2 September 1990. the state of Oceania is a party to that covenant. The Convention provides as follows. Article 13. 1. The child shall have the right to freedom of expression. This right shall include freedom to seek, receive, and impart information and ideas of all kinds, regardless of frontiers, either orally, in writing, or in print, in the form of art or through any other media of the child's choice. Advise Jean about the law.
Thank you. Thank you, Clarissa. What do you think? Australia, for example, is a party to the Convention on the Rights of the Child, and it is quite common for the courts, Federal Circuit Court, for Federal Court of Australia, as well as the Family Court. It's now been amalgamated to the Family Court and the Federal Court now, not to allow young children of very tender age to testify in court proceedings. But I wonder if that is a breach of the covenant on the Convention on the Rights of the Child.
Manjo, I'll have a go.
Yep.
I think that what we need to look at is what rights of the child. To testify to go and live with the father, if the domestic law determines an age limit where that can happen or where that's taken into consideration. I don't know if this is really Oceania that is preventing the rights of the child grossly. I think this is a father who, I don't know, he looks like he wants to benefit from his daughter testifying rather than having her rights infringed. I don't think it's a rights issue at all.
So by imposing this limitation on the child to express their freedom of expression before the court, as recognized in the Convention on the Rights of the Child, is that a potential breach of the convention? From tomorrow, would the judge not weigh up the delicate nature of the case and whether it is appropriate for a child to testify? I think that's what the judge did in this case. The question, though, is, in doing so, would the state of Oceania, for the actions of the Federal Circuit Court, be in breach of its obligations under the Convention on the Rights of the Child?
Is testifying before a court really a freedom of expression for a right for a child? Not really. It's testifying. They're having to give. They're being asked questions and giving answers to questions.
Correct.
Not the ideas aren't coming directly from their head. So I don't think I agree with Alonka.
Okay. Thank you, Peter. We have a comment here from Mercy. The child needs to be protected, and it may be inappropriate for the child to have to testify. From Ilionka, it depends on what other avenues are available. There may be other avenues available. There is the friend of the court in Australia. So what this signals us is that, again, how do you define the right to freedom of expression? At the end of the day, it's actually for exercising the state sovereignty. It's actually on the part of the state to determine how it interprets. Freedom of expression is pretty broad. And these rights, remember, are never absolute. There is the recognition that a lot of these rights under these covenants and conventions are not absolute. So it is up to the state to try to interpret, depending on its own peculiar circumstances, what it perceives to be a way of complying with its obligations under the covenant. That's one. because of the principle of sovereignty, and secondly, what we recall to be the prescriptive jurisdiction of states, the power of the states to determine what its own laws should be within its territory. Now, apart from that, the other thing we should never forget is that the mere fact that a state has become a party to a covenant or a convention or a treaty doesn't mean that that particular international law obligation becomes part of the domestic law of a state. Okay, because of the principle of incorporation. True, at the international level, a state may potentially be in violation of international law because of obligations of a state under a particular treaty. But it doesn't mean that these rights will automatically be translated into domestic law unless that the parliament, for example, or the legislature of a state would then incorporate the legal obligations of a state under a treaty as part of its domestic laws. Under the facts that we show in question 3, there's nothing that would suggest that the parliament or the legislature of that state of Oceania passed a law, in fact, making the Convention on the Rights of the Child as part of its domestic laws. So we need to remember that the entering into treaties, the way that states may become parties to the treaties, are actually actions on the part of the executive. These are not actions on the part of the parliament. And typically in most states, parliaments and legislatures have nothing to do with the way that states enter into treaties or become parties to treaties. This is purely on the basis of executive action. Even in Australia, it is the executive that does that. And in Australia, for example, the way that a treaty becomes binding upon Australia and for Australia to become a party is when it receives the approval of, or the consent of the approval of the Governor General in Council, meaning it is with the approval of the Federal Executive Council. So the Federal Executive Council, which comprises key ministers of the Commonwealth Parliament, they would usually review the treaty that Australia, for example, wants to be a party to, and by convention, if the Federal Executive Council informs the Governor General that they would like to be a party to the treaty, the Governor General is meant to follow the advice of the Federal Executive Council. So, which is why in Australia, it is not the Commonwealth Parliament that has the authority to approve or disapprove the power of Australia power of the executive to enter into a treaty. It has no such power because under the Constitution, this is a power that rests solely with the executive, as approved by the Governor General in Council, meaning upon the advice of the Federal Executive Council. So here, the other point we need to remember in question 3 is that it doesn't appear that the obligations of the state of Oceania under the convention are now really part of the domestic laws of the state of Oceania because it hasn't been incorporated or embodied in a domestic law. Okay, questions? Now, we had a discussion last time that because the obligations of a state under an international convention are really matters for the executive only, and they do not automatically become translated into domestic law or part of the domestic law because of the principle of incorporation, it doesn't mean therefore that it leads to rights on the part of the citizens on the basis of a convention or a treaty. But following the decision of the High Court, it has been said that it is possible it can lead to, for example, in the case of Peko versus Wolson, Wolson versus the Minister for Natural Resources and the Environment, the High Court had ruled that it can lead to possibly to legitimate expectations on the part of citizens that the state will try to act in accordance with its obligations under a treaty. But it doesn't mean it is a right, okay, unless the legal obligations are then incorporated or embodied in a domestic law as passed by a state's legislature or parliament. Questions? Very good. Okay. Question 4. Can I get somebody to read question 4 for us?
Yeah, I'll have another go, Manjo.
Thank you, Tamara.
The state of Venezia has for some time been accused by international lawyers of using repressive methods to quell the opposition. Of great concern among the international lawyers is the rampant incidence of desaparecidos, or individuals who have simply disappeared after being stopped and arrested by vigilante groups. More than 5,000 cases have to date been reported. Jose Gomez was one of the lucky ones. He escaped after having been detained and tortured by a vigilante group with potential ties to the state of Venezia. He is considering filing a complaint with the Human Rights Commissions against the state of Venezia for breaching its obligations under the International Covenant on Civil and Political Rights, of which it is a state party. Article 9, subsection 1 of the ICCPR provides, everyone has the right to liberty and security of person. No one shall be subjected to arbitrary arrest or detention. No one shall be deprived of his liberty except on such grounds and in accordance with such procedure as are established by law. The state of Venezia is also a state party to the optional protocol to the ICCPR. What advice would you give, Mr. Gomez?
Thank you, Tamara. So under the facts, you see here that it would appear it is not the state of Venezia that is responsible for potential violations about the right to liberty and security of a person, because it is undertaken by vigilante groups, which have nothing to do with the state of Venezia, it would appear. So from Ilionka, the state of Venezia is in breach if they do not actively take action to prevent and bring to book the actions of the vigilante groups. Okay. What do the others think?
Domestic criminal issue.
Sorry?
It's a domestic criminal issue.
Okay. So the question is the state of Venezia, as suggested by Ilionka, in violation of its obligations under the convention? Let's assume from Tamara, she's asking a question, how involved is Venezia? Or how aware is it of the vigilante groups? Let's assume that it is aware, but it's not putting a stop to it. The question is, does the state of Venezia under the covenant have an obligation to do more than just respect rights? Because remember, this was the suggestion of the typology, right? Under the typology of obligations, you can respect it, meaning, respect, you don't refrain. You don't interfere with it. But what if the interference is not done by the state? It's done by a vigilante group or third-party individuals. Is there a requirement that the state must do more, in which case it must try to promote the right or protect the right? Is there an obligation? From Tamara, the more involved, the more likely they're in breach. From Jack, if they have the capacity. Because remember, as you said, before a state, before an individual can file a complaint with the Human Rights Commission created under the International Covenant on Civil and Political Rights, there must have been an exhaustion of domestic remedies as well. Okay, and let's assume that the opposition has done its best to try to ask the state of Venezia to try to stop these incidents of desaparecidos, or individuals have simply disappeared, which was quite common in Argentina and I think in Chile before. The question is there an obligation on the part of the state of Venezia? If it isn't doing it itself, it's being done by vigilante groups. Is there an obligation to do more? From Ilionka, the state is probably instigating and funding the vigilantes. So okay, comments? So from Tamara, hence my comment, read the more involved. So the more involved the state might be, so it might be really in violation. So there has been a report coming from the Human Rights Commission that a state may be in breach of its obligations under the covenant if it all it does is just to respect the rights, meaning it doesn't interfere itself. If it doesn't seek to protect the right by stopping individuals or groups who are actually violating the rights guaranteed under the ICCPR, the state will be in breach of its obligations. So there is a recognition already from the UN Human Rights Commission, not binding, but it has a palpable effect in the international community, that it is insufficient for a state not to do it, to refrain from, from just merely respecting. It needs to take a more active step to address the problem by, for example, under the facts, to try to put a stop to the desaparecidos, to try to put a stop to the vigilante groups who are themselves responsible for the violation of the rights to citizens as guaranteed under the International Covenant on Civil and Political Rights. So from Jack, the state of Venezia has an obligation to protect the rights of its citizens. If the state has made no effective effort to put a stop to the vigilantes, it would be a breach, and I would agree with that. From Ilionka, more than 5,000 cases. I reckon the state is well aware of the issue. That's right. From PIDA, if all domestic avenues have been exhausted without any assistance of the state, it is in breach. Okay. So at least now we see that when it comes to international human rights obligations, sometimes for a state to merely respect a right would be insufficient. It would need to either promote it or to protect it. It has to do more. Okay, so it is not an excuse on the part of the state to just say, I'm not responsible for doing it. It's somebody else. So it could be, it could be issues about violation of labor rights of individuals. And it isn't the state doing it, but it could be, trade unions. It could be managers, unions trying to crush workers' rights and so on. In that case, there is an obligation on the part of the state to do more, to just not refrain, but actually to make sure that the rights are protected or the rights are promoted. Okay. So final question, we're now going to the question that is about the quiz. Can I get somebody to read the quiz question for us? And I'm just going to disappear for a while somebody reads it. I need to grab a glass of water. But can somebody just read the question, please?
I'll do that, Manjo. Jeff Edwards, a citizen of the state of Ballina, has for a long time been unable to find a job and has been forced to live on the streets for some time. He has often been asked by the police to leave, in which case he'd try to hide in public parks or some secluded place to sleep. With money coming only from alms he gets from passers-by, which isn't really much, he is often... Hang on, I've got a problem. He is often hungry and without food. While sitting at a bench at one of the public parks one day, he had the chance to talk to a lawyer who told him about the 1966 International Covenant on Economic, Social and Cultural Rights, ICESCR. The state of Ballina acceded to the ICESCR but not ratified it. The lawyer told Jeff that Article 11 of the ICESCR provides the states parties to the present covenant recognise the state of everyone to an adequate standard of living for himself and his family, including adequate food, clothing and housing, and to the continuous improvement of living conditions. The states parties to the present covenant recognising the fundamental right of everyone to be free from hunger shall take individually through international cooperation the measures including specific programs which are needed. Just got to wait. Okay. Which one of the following statements is the most correct answer. The state of Ballina acceded to the convention but not ratified it is not bound by the convention under international law. The state of Ballina is not in breach of the covenant. The state of Ballina is in breach of the covenant for failure to provide Jeff an adequate standard of living, including adequate food and housing. The state of Ballina is in breach of the covenant for its failure to comply with its international law obligations that everyone be free from hunger. All of the answers are wrong.
Thank you. Can I get everyone to try to post his or her answers in the chat box? So we've got A for several students. We've got Ernest saying D. Oh, hello, Ernest. I'm glad you're here. Was just answering one of your emails earlier. Welcome. So a lot are answering A. Most have answered A. Ernest has answered D. Ilionka has answered E. Ainsley has said, I have no clue. Okay. Okay. So the A as an answer states that the state of Ballina, having acceded to the convention but not ratified it, is not bound by the covenant under international law. Let's clarify that first, because a majority of the students say that that is the correct answer. So when a state has merely acceded to a convention but not ratified it, does it mean that that state is not a party to the convention or is not bound by the convention? What's the difference between ratification and accession, in other words? From Ilionka, is acceding the same as ratifying? In terms of actual acts, they're not the same. The way you accede is not the same as what you ratify. If the question is, do they have the same legal effect? That's a different question.
Sorry, Manjo, my understanding is that if you ratify, you were part of the original agreement.
That's right, yeah.
And acceding, you come in later, but you have the same legal obligation as the states. Is that right?
That's right. So Ilionka got it correctly. Both acceding and ratifying a treaty have the same legal effect. It binds a state. As correctly pointed out by Ilionka, if a state ratifies it, it assumes that the state is an original signatory to the treaty, and then it ratifies it. Those who accede to a treaty are usually the ones who become parties to the treaty after the treaty has come into force. So they are not original signatories. So usually, therefore, states, when they put their signatory, put their signatures to a treaty, it is for that signature to have the effect of binding the state means that it has to be ratified. There has to be the ratification. So it's subject to ratification or accession. Accession means it happens later. So it cannot be A, because acceding and ratifying have the same legal effect. It makes a state bound by the treaty. The other answer is D. The state of Ballina is in breach of the covenant for its failure to comply with its international obligation that everyone be free from hunger. What do you think? So remember, we talked about typologies of obligations: respect, protect, fulfill. Is there an obligation on the part of a state to fulfill its obligations under the International Covenant on Economic, Social, and Cultural Rights? For mercy, yes. Now that can be very problematic, don't you think? Remember, there are so many rights under the International Covenant on Economic, Social, and Cultural Rights: the right to a living wage, adequate physical and mental health infrastructure, right to housing, right to free education. Can you imagine how difficult it can be for states to comply with those obligations if they become rights? From tomorrow, perhaps, if the shit hit the fan and food sources were scarce for the whole nation, but for one individual, that's the other point. Oh, but that's actually a good point here from Tamara. We're talking of a single individual. How can you, how can you say that it's widespread? It's difficult to argue that the state is in breach of its obligation simply because one individual doesn't have any food or doesn't have any housing. Good point. That's a good point. I would agree with that. But assuming it's widespread, assuming that there are thousands upon thousands of individuals, like as Faye pointed out, like Venezuela at the moment, who do not have access to food, who do not have any access to housing, is that a violation of the international obligations of a state who might be a party to the covenant? Like Venezuela is a party to the International Covenant on Economic, Social, and Cultural Rights. Would it be in breach? So the correct answer here is that the state of Balina is not in breach of the covenant, okay? For two reasons. Number one, it is a general principle law. There is an understanding that the ability of, the compliance by a state of its international obligations concerning human rights may actually be subject to its capacity to do so, its wealth, the infrastructure, and so on. And in fact, this particular principle is recognized clearly in Article 71 of the 1966 International Covenant on Economic, Social, and Cultural Rights, where it is the state parties are obliged to provide a report to the Economic and Social Council on the steps that the state is taking to comply with its obligations under the covenant, and secondly, for a state to report any factors and difficulties that may be affecting the state's ability to comply with its obligations under the convention. So there is no requirement to fulfill, because states are uniquely positioned. Not all states have the capacity to do so. It's kind of on a best efforts basis. It depends on the ability of a state. So the correct answer is the state of Balina is not in breach of the covenant, because the obligations under the International Covenant on Economic, Social, and Cultural Rights does not mean that there is an obligation of a state to fulfill. It's essentially an obligation to just respect. Okay, so it's 8:03. We've covered the 5 questions. Any questions before we end tonight's tutorial? From Emma, will we have a shoot next week before the take-home papers review shoot? Yes, we will. So instead of having the shoot on Wednesday, I think we're doing it on Monday, was it? Or was it Tuesday? I can't remember now. I think we're doing it on Tuesday, right? We're gonna do it on Tuesday at 7, because I think the final take-home paper questions will be released on Thursday. So we're having a shoot on Tuesday and not on Wednesday, because it's gonna be too late if it's gonna have to be the day before. Okay, and I'm hoping that most of you watch it or join, or at least watch the recording, because I'm gonna provide some guidelines, what the questions to be covered will be, and how to address some of these case scenario questions. Okay. Question? Yes?
Just a quick question.
Yes, Jack.
With the principles of incorporation, is there, I know the Department of Foreign Affairs and Trade have a Australian treaties database. Is there anything within that to sort of explore how those treaties have been incorporated into Australian legislation at all that you know of?
I'm not aware of the facility. The crucial point is that when you speak of incorporation, what it really means is that the obligations of Australia have been converted into a domestic law. So in other words, Parliament passed a law embodying the obligations of Australia under the treaty. From Clinton here, DFAT, yeah, okay. So there seems to be a link, as provided thankfully from Clinton here, on the part of the Australian government as to what international treaties there might be. The question we have though is that, have these treaties become incorporated into laws in Australia? I don't know. I'm not sure.
Okay, so there's, if you were trying to find it, I'm just wondering how you would go about researching that. It's probably a bit off topic, but it was just, it's got my curiosity.
Yeah, good point. I wouldn't know.
Okay.
Okay. Any other questions? We're good. Okay then. So have a great weekend ahead of you and enjoy the exam, the final paper next week. Thank you. See you soon.
Night, Manjo.
Good night. Bye.